A very warm welcome to this Oxford webinar on Interdigital versus Lenovo, an immediate reaction and discussion to the appeal court's decision from last Friday. And yeah, we're very happy to welcome Pete Damrell and Tess Waldron from Paul Gilbert to this webinar. Pete Damrell and Dr. Tess Waldron are both partners with Paul Gilbert in the London office and work on Frand and standard essential patents. And we're extremely pleased to have experts on this call to discuss the results of the Court of Appeal in the decision Interdigital versus Lenovo. I think this decision is a landmark decision that has once again illustrated the thought leadership of the United Kingdom when it comes to standard essential patents and the determination of Frand rates with an international impact. The English judges have given this question a lot of time and attention and have thought very thoroughly. With the result, I would say that by and large the Court of Appeal has confirmed the lower courts and has by and large confirmed Judge Mead's thinking on Frand and on Frand valuation. And with that very brief introduction, I pass this now on to Pete and Tess, who will discuss the legal aspects of the decision and also that of the High Court. And I will interfere and discuss it a bit from an economic perspective and why it is a very important decision from a Frand royalty rate determination point of view also. Good, and I will now bring up your PowerPoint. Meanwhile, feel free, Tess and Pete, to already start discussing while I fuzz around with my IT. Oh, that was faster than usual. Okay, so Interdigital versus Lenovo.
Brilliant. Well, thank you very much for the introduction, Roya. Welcome, everyone. As Roya mentioned, we're going to focus primarily on the appeal decision, but before we can do that, we just wanted to give a brief summary of Mr. Justice Mellor's decisions that were under appeal. Roya, if you could move on to the next slide, please.
Just go on. I don't know whether here you go.
Okay, thank you. Excellent. So, this dispute concerned the Frand terms for a 3G, 4G, 5G license between Interdigital and Lenovo for the period up to the 31st of December last year. Now, as I suspect many people will know, there's been more litigation between Interdigital and Lenovo in terms of the rates that should be paid after the end of 2023. But this dispute relates to the pre-2024 period. Lenovo had been held to infringe a couple of UK SEPs, and they sought to rely on Interdigital's Frand undertaking to avoid an injunction. And the decisions under appeal are the decisions that came out of the Frand trial. Now, this took place over 17 days in January and February 2022 before Mr. Justice Mellor. And there was very extensive fact and expert evidence. So to give you a flavour, there were over 50 bundles of materials, 23 statements from 10 fact witnesses, 30 reports from 14 experts, and 760 pages of written submissions. And then obviously also all of the oral submissions and cross-examination that took place during the 17-day trial. The main judgment was from around March 2023, and that date dealt with the Frand terms for the license and some issues as to whether or not the parties were willing licensors and licensees. And then, as is usual in the UK, there are a couple of other hearings, actually, a form of order hearing, which issues relating to costs and permission to appeal were discussed, but also importantly, that second judgment also dealt with the issue of interest. Now, the key findings were that Mr. Justice Mellor held that the Frand rate would be 17.5 cents per unit And importantly, this was payable on all sales from 2007, so the entire period in which Lenovo were unlicensed. And this gave rise to $138.7 million. And then the judge also awarded interest on the royalties due on the past sales, which came to 46.2 million, so 184.9 million in total. Now the chart shows those figures in the middle column, and then on the left we see Lenovo's lump sum offer going into the trial, which was 80 million plus or minus 15%. And Interdigital's lump sum rate going into the trial, which was 337 million. Now, the judge held that because all of the offers that Interdigital had made, or most of the offers that they'd made during the discussions were all above the Frand rate, he held that Interdigital did not act as a willing licensor. And in relation to Lenovo, he said that they were a willing licensee for the most part. Given that the rates that were awarded were much closer to Lenovo's contentions than Interdigital's, Lenovo were held to be the overall winner when the judge was looking at it from a cost perspective. Now, the appeal took place in June 2024. It was a week of Court of Appeal time, which is a very long appeal hearing by English standards. And the judgment was handed down very quickly on the 12th of July. Next slide, please, Roya. So just with that background, for the rest of the webinar, we're going to start with a more detailed dive into exactly how Mr. Justice Mellor came up with his Frand terms. And Roya is going to talk us through some of that and make some comments on that from a valuation perspective. We're then going to give a very brief overview of the appeal and the sort of test that the English court applies on appeal. And then we're going to look at the four main points on appeal. So Lenovo had 2 points by way of cross appeal, one on limitation periods and one on interest. And then Interdigital had, they had 4 points on appeal. Actually, the first three all really related to the Frand rates. And then the fourth was that Interdigital was seeking a declaration that they're a willing licensor. And then we're going to finish with some brief conclusions and observations. All right, next slide, please, Roya. Okay, over to you, Roya, to talk us through a little bit about the Frand terms that Mr. Justice Mellor found.
Thank you very much. So I think I'm extremely excited that we have more jurisprudence now on how to value Frand rates, because all of this sheds more light on how on earth to do it. And I think it is an excellent thought process that underlies this judgment. And I'm quite proud of how thoroughly the English judges keep thinking questions through, which are usually a bit out of their usual qualification and training, and are open to economic assessments. So when we look at how Judge Mellor, please apologize, I mixed up the names in the morning, came to grips with that question. He first looked at previous judgments, and he looked up the methodologies that were previously undertaken by other judges. He obviously, given as an English judgment, hinged it, in my opinion, by and large, on the decision Justice Bursin Anwar Planet versus Huawei. But he also recognized judgments, for example, from the United States, such as INRI Innovatio or TCL versus Ericsson. TCL versus Ericsson, in spite of the fact that the judgment was vacated, was still recognized as a very helpful instrument and means to come to grips with the question of the methodology underlying the valuation. When looking at the valuation, the judge recognized two principal approaches. He recognized the comparable licensing approach, and he recognized the top-down approach. As a matter of fact, he did not recognize hedonic price regression and refused to acknowledge it, and actually criticized the party that advanced that methodology for not having exactly followed some procedures, which I'm not totally clear what was wrong, but he refused hedonic price regression as a cross-check of the comparables. So just to bring everybody on speed on the same level. So what are comparable licensing doing? I think the underlying reasoning behind comparable is very simple and easy to understand. You're trying to understand one question with the help of another question. So you're trying to establish if the current licensing relationship is similar to a past licensing transaction, and if the comparables are not totally comparable, you're trying to adjust it to the best extent possible. The advantage of these approaches is that it helps you recognize the non-discrimination prong of Frand and seeks to set an equal level playing field among market participants. Overall, however, also it must be said, independently from Frand, looking at worth with respect to comparables is fairly easy to understand, widely acknowledged and used also in damage assessments for patent infringement proceedings, generally speaking. Now, the top-down approach is a different animal. It is addressing another element of Frand. What the top-down approach does, it gives you an aggregate rate for the standard as a whole. And it offers you one single rate, and then you need to figure out what percentage rate of this total aggregate rate would be the value of this specific standard essential patent portfolio that is under debate. There have been different ways of both figuring out the aggregate rate and figuring out the percentage or the part that composes that little element. In the Innovatio case, which the judge made use of, they actually used the top-down approach as a principal method and not as a cross-check. And they did hinge the top-down approach on the Wi-Fi chip. So what the judge in this case did was that he looked up what is the typical value of a Wi-Fi chip. And then he said, okay, what percentage of that cost or that value can I attribute to this portfolio? This is not what happened here. In this judgment, the judge looked up really what is the aggregate rate of the standard as a whole and how many standard essential patents are on the respective standards, only as a cross-check to a comparable rate. And so it was used as a secondary method, but it is still important because it allowed you to understand really the question even if hypothetical, and if the risk of a royalty stack of many multiple licensing requests for many different SEPS owners is still affordable. Now, what Interdigital then said was like, well, let's run a cross-check on this cross-check with the help of hedonic price regression. And that was not accepted by the judge. And hedonic price regression is a very fancy word to basically understand consumers and to understand what consumers want. It's a method that comes from marketing. It's not a method that was designed for patents. It was slowly introduced over time by some consultants to suggest we should really look at what the consumer wants and run surveys and help understand what people want. And this method is perhaps interesting in helping to understand demand. It assumes, however, that the consumer has a choice, and that may be a limitation of this methodology. So another point which I got quite excited about is how the judge looked at value. If you value something, you need to have an inherent working definition what you mean with value. And how this was looked at in Interdigital versus Lenovo was that he said, value is not what it's worth to you personally. Your own kids are always the best kids in class, obviously, but value is what would, in a decent transaction at an arm's length, basically be the price that could be determined between a willing licensor and a willing licensee. So in a way, this notion of value reminds me more of a notion of price and price setting rather than value. And by introducing this rationale that value is basically what would you be willing to pay at an arm's length transaction between a willing licensor and licensee, reminds you very much of another valuation method, which is the hypothetical negotiation, which was also used, for example, in the Innovatio case, which says, let's imagine an ideal scenario without fighting, where people would have, ahead of the infringement, ahead of time, just discussed it out, what would have been the worst. And so these were basically the principal methods that were applied here. In terms of the top-down aggregate rate, the judge kept on simply counting standard essential patent declarations, as was done in Unright Planet versus Huawei. We know it's not perfect. Basically, under the logic, we know it's not perfect. It's the best we can do to not become too arbitrary. What is also exciting in terms of comparables, what constitutes a comparable licensing rate is a very important question to ask, because you don't want to confuse apples and oranges. And here, this judgment offers us additional insights, because it helps us, it basically defined a comparable valuation, a comparable licensing agreement by recognizing basically just one single licensing transaction that Interdigital had concluded with LG, because they said these were similarly situated market participants. The market situation was similar. They had differed similarly in the market size, the geographic distribution. All of this kind of like is very similar to this situation here. But the judge did not simply accept that Interdigital had just concluded lots of licensing transactions, and actually said, I don't find them comparable except for this one. And the reservations, for example, that the judge introduced was that they did not cover the market share properly. And a big red flag from what I read was for the judge, the question of discounts. And he took issue that big company like Apple got a huge discount, and a tiny company like Fairphone got no discount at all. And I think this brings up a bigger picture with respect to discounts and carrot and stick licensing, which was also already criticized, for example, by the Korean Fair Trade Commission, when it, up to the Supreme Court, held up its reservations outwards to Qualcomm. This is my very, very brief intermezzo. I think it is really important that in England, the judges took the time to analyze this. I think it would help. It sets England apart from the continent, where there's less time to assess value, and where injunctions are basically issued much easier, and there's less consideration of the legal remedies at stake in terms of damages and rate setting. And I think it would set an equal level playing field if there were more economics in the courtroom. And that I leave with this very brief intermezzo to our legal experts to continue their debate.
Thanks,
and I haven't heard anything that you wrote on your chart. I apologize.
Could you move it on to the next slide for me? And the next one. Okay, fine. So just before we sort of delve into the appeal itself, I just wanted to recap for people who are perhaps a bit less familiar with the English appeal system, that effectively we obviously don't have de novo appeals. You can appeal on points of law, or if you can say that the judge has basically got it wrong on the evidence. So, you know, where a first instance judge has made a sort of multifactorial decision on the basis of the experts and the materials in front of him, the appeal courts are normally very slow to interfere, but they will have a look at things if the judge has made a significant error of principle, or as highlighted here, if there's a sort of inconsistency or flaw in the way in which they've approached a question, even on the basis of the evidence. So in this appeal, Interdigital, as Pete was saying, were concerned about the rate and about whether they were or were not a willing licensor. And we'll come on to look at the detail, but their appeal on the rate was at least partially successful. Their appeal about whether they were a willing licensor was basically dismissed as being irrelevant. And then Lenovo cross-appealed on this limitation point and the interest point. And, you know, there's a lot of interesting detail in the methodology in the first instance judgment, and in fact on lots of other things. But I think the key points of principle are really this limitation point and the subsidiary question of interest, which is a significant part of the Court of Appeal's judgment. So if you could flick over to the next slide, Roya. So this is just a summary of where we got to on first instance in terms of limitation. Some good quotes from the judgment, but basically Mr. Justice Mellor said there's no role for limitation in the Frand context because a willing licensee will set aside notionally or otherwise the money it needs to pay for the license. And part of the rationale for doing this is to remove an incentive for holdout. So on appeal, Lenovo mounted a pretty comprehensive attack on this. And Roy, if you go to the next slide, I think it sets out all of the arguments that Lenovo made. The sort of too long didn't read summary is that they all rejected, but taking them each in turn. One of Lenovo's arguments was that limitation is a sort of fundamental principle of law, you know, effectively globally, and so shouldn't be disregarded. And the Court of Appeal rejected that. They said the judge was right that limitation has no place in Frand. The implementer needs a license from when it first starts to implement the standard. The ETSI guide and the FAQs make it clear that a willing licensee doesn't just sit back and wait to be pursued, but proactively contacts the SEP owner and should be putting money aside pending agreement of the license. They said in an ideal world, the licensee and the licensor would reach an agreement nice and quickly, but if not, they would in any event negotiate a standstill arrangement so that limitation time would cease to run and limitation wouldn't be relevant. They said the relevant date from which payments should be made at the very latest is going to be first contact between the parties. And they observed that because Frand terms are supposed to be available to anyone, they shouldn't be affected at all by the date on which the license is concluded. And in fact, that would reward implementers who were slow to take a license, when in fact, if anything, it should be the other way around. So the people who were quick to agree a license should perhaps get more favourable terms. So Lenovo also said, well, it's not just our fault because it's up to the claimant to bring their case, and Interdigital could have done so at any time. And I mean, the Court of Appeal didn't have a lot of time for this either. I mean, fundamental to their analysis, and we'll come back to this probably a few times, is that Frand is in the end conduct neutral. So this is a bit of a divergence again for the UK from other jurisdictions. But in the end, it's the fair and reasonable sum paid by the implementer to the SEP owner for use of the SEPs. And it doesn't really matter who caused the delay, the implementer, the patentee, or the combination of both. It doesn't change matters. The technology needs to be paid for at a fair rate. The court also thought this was really just a repackaging of the limitation as a principle argument, which they'd already rejected. And they said, well, that's all very well, Lenovo, but you also could have brought proceedings, or you could have just accepted one of Interdigital's argument offers to arbitrate. Linked to this, they said that it was difficult to conclude a license because Interdigital were demanding the super Frand rates. But again, the court said it doesn't really matter who's at fault, because at the end of the day, it's just about the right sum paid for the technology. And they noted in any event that the judge didn't find, although the judge said that Interdigital's behaviour was, maybe not that of a willing licensor, he didn't make a finding of fact that behaviour had in fact delayed the agreement of Frand terms on the facts neither side had made a Frand offer. And they reiterated that the implementer shouldn't be rewarded for delay, and that if the patentee's behaviour is truly awful, which it obviously wasn't in this case, then the court has other sanctions. It can, in certain circumstances, and we'll come back to this, deny or reduce the interest payable, or there can be consequences in terms of the cost of the Frand proceedings in the UK, where normally we have a cost shifting regime, but that can be affected by the conduct of the parties. Lenovo also made the point that just because you're in negotiation with somebody, you shouldn't have to give up your limitation defences to which they would, you'd usually be entitled. And as to this, the court said, well, Interdigital is not making a claim where the limitation would be relevant, as we've said. They're asking the court to determine what a willing licensor and willing licensee would agree, and that's the terms that Lenovo would have to accept to avoid a Frand injunction. So the context and the purpose that we're talking about, that Frand is sat in, is very different to a damages claim, and these arguments aren't really relevant. The next point about limitation should be blind to the merits of the case, so it shouldn't really matter, regardless of whether your case is great or whether it's terrible. Again, the Court of Appeal said just misses the point, because we're not in that context. We're in the willing licensor or willing licensee paradigm, and limitation isn't relevant to the assessment of Frand terms. Next, Lenovo said that the English court should be slow to disregard limitation, because it effectively sort of would disregard the approaches that other jurisdictions might take to that issue. In particular, those jurisdictions where the effect of limitation can sort of extinguish a cause of action, so you can't even bring a claim, rather than just restricting its remedies. And they said that the approach of Mr. Justice Muller just encouraged forum shopping. The Court of Appeal, and it's mostly Mr. Justice Arnold here, with whom the others largely agreed, although they do give judgments of their own. He said, well, that doesn't work either, because the approach that you're complaining about doesn't substitute UK limitation periods for the limitation periods of other jurisdictions. It's effectively forum neutral, because all it's doing is disregarding limitation entirely and working out what the Frand terms between the willing licensor and willing licensee would be. And he observed in passing that this was effectively a temporal version of the arguments that were made in front of the Supreme Court about comity, and saying that the UK court shouldn't substitute its assessment of rates for those of other jurisdictions. So they thought this was just a repackaging of the same point, or perhaps approaching the same point from a different angle. Lenovo also said that Mr. Justice Muller's approach basically gave no incentive for SEP owners to make reasonable offers. In fact, they could make super Frand offers, because there would be no risk of limitation cutting off their recovery. And again, the Court of Appeal said, well, this is a kind of straw man argument, because the SEP owner is never going to get more than Frand from the court. And in fact, your approach would just encourage implementers to be as slow as possible and drag their heels. And it's no real answer to say that the SEP owner can just start proceedings, because first, Frand ideally should be negotiated without recourse to the courts. And second, the logic of Lenovo's position is that the SEP owner would have to start proceedings, in multiple jurisdictions to kind of stop the limitation clock in each one of them. And they noted here in passing as well that, as the UK court has observed quite frequently, and including in the Supreme Court My Planet decision, the effects of delay tend to be asymmetric and to favour implementers. So there can be no real, they just didn't agree that it would incentivise SEP owners to make excessive demands. And again, they reiterated at the end of the day, all they're going to get is a Frand rate for past sales. So once that is concluded, it's no benefit to them anyway. And then they made a few sort of, I suppose, technical, slightly points on the pleading. So they said, well, okay, fine, but Interdigital never actually asked for royalties in respectable past sales, so they shouldn't be able to get that now. The Court of Appeal said, we don't accept that they may never have specifically pleaded the point, but they never conceded that they should not recover in terms of past sales made more than 6 years before the effective date of the license. I think they were 7.5 years they asked for, which is obviously longer than the UK 6-year limitation period. And more generally, the sort of pervasive theme in their case is that they should get a significant uplift on future royalties to take into account the absence of payment for, pre-2012 royalties. So that didn't work either. And then they made a sort of factual point about the fact that the parties had agreed that limitation was taken into account in actual negotiations, and that the approach of the UK court was to try and simulate what industry practice, or at least to take industry practice into account. And Mr. Justice Arnold said, well, that's confusing 2 points, really. There's one question about whether limitation is relevant as a matter of principle. And then there's another question about what licensors have previously had to do for reasons of pragmatism, faced with difficulty in enforcing their rights. And to the extent there is an industry practice of recognising limitation, it's nothing more than the licensors just recognising the reality of the commercial situation they're in. And in any event, there was no evidence in the licenses in front of the court of a settled approach. I think none of the Lenovo 7 had a term releasing sales more than 6 years old. The nearest to that was the LG license, which apparently had a release of 6 years and 11 months before the effective date. And then as a sort of last throw of the dice, Lenovo tried to invoke this theoretical jurisprudence where the Court of Appeal or courts generally can make rulings that are prospective in nature, so they don't affect what's happened previously, they just affect cases brought subsequently. And the Court of Appeal dismissed this as completely untenable. They said, well, we've theoretically got this power, but it's never been exercised by a court in the UK, and this isn't the case where we're going to change that. So I think a very comprehensive confirmation that the limitation won't play a role in the UK Frand determinations unless the Supreme Court does something different. So that's the situation we have here. I mean, linked to this, and if you could just flick on to the next slide, Roya, there was a question, as Pete was alluding to, about interest. And in front of Mr. Justice Mellor, Lenovo argued that Interdigital shouldn't get interest because the judge had found that they were not a winning licensor. And again, the judge said, well, that was just conflating what is Frand and how you determine Frand. The inclusion of interest is part of the first question, so it goes to what is the Frand payment. And it's difficult to see why it should be affected by the process, which can be addressed in costs as necessary. Now, it's worth noting, as the Court of Appeal did as well, that in extreme cases it might be that interest wouldn't be awarded, but I think it would have to be pretty extreme for that sanction to come into play. Lenovo also argued at first instance, in a way that they subsequently did on appeal, in terms of the limitation point, that the award of interest would just encourage the SEP owner to make super Frand offers, because the worst they would always get is Frand plus interest. But the judge rejected this on the basis that the implementer could always protect themselves by making payments on account and or starting their own Frand determination. And I think it's also worth noting as a point of principle that interest is basically it's not aimed at benefiting either side, it's aimed at making the delay economically neutral. So it shouldn't be advantageous to the implementer who retains money the court should have been paid earlier. And it shouldn't be advantageous to the SEP owner. It should just put them in the position they would have been in had the money been paid at what the court regards as the correct time. And these are just the paragraphs of the judgment that set this out. So if you could just flick over for me, Roya. I mean, this was a bit less detailed analysis of this in terms of appeal. I think there were fewer points raised. So Lenovo's sort of first prong of attack was that there was actually no power for the court to award interest. And it's true that there was no statutory or common law or basis in equity for interest to be awarded as a matter of UK law. But I think it was common ground that it might arise on the basis that that's what a willing licensor and willing licensee would agree to. And in relation to this, the Lenovo said, well, the ETSI policy and guide don't say anything about interest, so it shouldn't be payable. And the Court of Appeal said, well, that's true, but those documents don't say anything about actually, how to determine a Frand rate or what is Frand either. So that's not really relevant. Lenovo also said, well, there's no evidence in the comparables that interest is levied on past sales. And as to that, the Court of Appeal said, well, that's not surprising because there's been a whole wealth of evidence in this case and about how past sales are discounted very heavily because of the difficulty in recovery. So it's not surprising that interest isn't potentially levied. And in any event, you haven't been able to point me to any evidence of settled industry practice that interest is not paid on or should not be payable on past sales. And then slightly, in a way that I suppose was slightly inconsistent with the previous point, Lenovo also said, oh, well, if there is interest, it's all swept up in the lump sum during negotiation. So you can't take a lump sum as your comparable and then add interest to it because it's already built into that figure. And the Court of Appeal just said, well, no, that's contradictory. And actually, they didn't deal with that point in a huge amount of detail. Stepping back, they just said, yeah, sorry, Roya.
Can I say something on the lump sum? I think from a valuation perspective, that is also really an exciting point, because the lump sum, there's always a debate, should you make a licensing rate on the basis of a lump sum or on an ad valorem basis, or how do you organize it? And I understand that often competitors are not so keen of disclosing every year what exactly they have been selling, how much they have been selling, and where they have been selling. So it is in their interest rather to offer a lump sum. And on the other hand side, perhaps from a licensor's perspective, it's preferable to have a per unit licensing rate. And I was really excited to see that the judge was addressing these matters in his judgment. And I thought this is really someone who knows what is going on and how people tick, and that matter of transparency was discussed. And I thought, wow, very excited to read such sophistication in a judgment.
Yeah. I mean, so I suppose taking a step back, the Court of Appeal basically said the overriding consideration really is that the timing of a payment of money should be economically neutral. And they said, it's particularly applicable in the present context in relation, and sort of referred back to their findings on limitation, saying, implementers need a license from day one. The in principle terms should be agreed at that date or shortly thereafter, and there should be no incentive for the implementer to delay. And all of these factors point to the conclusion that a winning licensor and winning licensee would agree to the payment of interest so that the passage of time was cost neutral to both sides. So in short, interest should be payable. And then just in terms of, then they said, well, you shouldn't make any award of interest because Interdigital were not a willing licensor. And the court basically said, although we accept in principle, there are cases in which interest should not be payable. This is not such a case. It was up to the judge. He had all the evidence in front of him. He made a decision that interest should be paid, that Interdigital's conduct was not such that interest should not be paid, and he was well placed to make that decision, and we're not going to overturn it. And then just very quickly, in terms of Lenovo's points that the rate should have been lower, this time period should have started later, and the interest shouldn't have been compounded. I mean, in effect, they said a lot of this is an evaluative decision with proper evidential foundation that the judge was entitled to make, in terms of saying that interest should only run from the time the Frand license was on the table, so effectively from the first instance judgment. That's just another way of saying there shouldn't be interest on past sales, and we've rejected that as a point of principle. So that's where we've come out on limitation and interest, which are obviously, relatively, well, I think pretty favourable outcomes as points of principle for patentees. But I'll hand back to Pete now to talk about how Interdigital got on and its appeal on the rate.
Brilliant. Thanks very much, Tess. Roya, would you be able just to actually flick back to slide 5, which is the one headed Frand rate first instance decision? Sorry, no, other way. Back towards the beginning.
That one?
No, back earlier. I'm just going to give a very quick summary of how Mr. Justice Mellor, that one, yeah, brilliant, thanks, Roy. Yeah, so before I delve into the points that were made by Interdigital to challenge the Frand rate decision on the appeal, I'm just going to give a very quick overview of how Mr. Justice Mellor came up with the numbers ultimately, and Roy mentioned some of this earlier. I apologise, this will be trying to cover about 500 paragraphs in 2 minutes from Mr. Justice Mellor's decisions at a very high level. But essentially, as Roy mentioned, the focus was on comparable licenses. Interdigital had relied primarily on 20 licenses, mainly with small players. I think these accounted for just over 2% of their license sales. And the judge held that these were not relevant comparables at all. Lenovo were focusing on 7 licenses with the large mobile phone manufacturers, and the judge held that these were far better comparables. But then he focused in more on a license with LG from 2017, which he held was the best comparable and the best place to start. And this because it had LG, the situation between LG and Interdigital was most similar to that between Lenovo and Interdigital. But in terms of actually coming up with numbers from the LG 2017 analysis, essentially the parties ended up using IDC sales data for Lenovo sales, and then the experts derived various numbers from the LG license. So one approach was to divide the license into past sales and future sales, and the choice of how to allocate the revenue from the lump sum between the past and the future was based on primarily on sort of Interdigital's own assessment as to what it said was to do with the past and what it said was to do with the future. And this relied on things like SEC filings. And so the experts did an analysis where they came up with a past rate, a rate for past sales, which was very, very low, and a rate for future sales, which was much higher. But then the experts also did a blended rate where they took all of the sales over the entire period and came up with one blended rate for that. And ultimately, the judge used the blended rate, which, based on the unpacking by the experts, he found was 24 cents per unit. So that was the blended rate for LG. And then the next step was to decide whether that needed any adjusting for Lenovo's situation. And there were various factors that were considered. And ultimately, the judge applied an adjustment factor of 0.728. So applying that to the 24 cents gave a per unit rate of 17.5 cents. And the judge applied that to all of the Lenovo sales since 2007. So just bear in mind those numbers, 24 cents per unit, and then the adjustment rate of 0.728. Okay, Roy, if you could now move on to the slide on the Frand rate appeal. So just after, yeah, that one. Excellent. Thank you, Roy. Okay, so Interdigital's grounds of appeal on the Frand rate. They had 4 grounds. The first 3, so they had three on the rate, and then the 4th was on the finding that Interdigital were not a willing licensor. And in relation to the grounds on the rate, their first argument was that the judge had applied the wrong dollar per unit rate from the LG license. So that's the 24 cent rate. And they argued that the judge failed to correct for non-Frand effects, which he had found had affected past sales. The second ground was that the judge had applied the wrong adjustment factor. That was the 0.728. Again, basically because he hadn't taken into account the non-Frand factors on past sales properly. And then the third ground was to say that the judge was wrong to reject the simpler of the 2 top-down analyses. So as I mentioned on the blended rate, the judge had decided, on the per dollar rate or per unit rate, the judge had decided to apply the blended rate of 24 cents. And Interdigital effectively argued on appeal that this was the wrong thing to do because it didn't fully account for non-Frand factors with past sales, and instead the judge should have applied the future-looking rate, which was 61 cents. Now, Interdigital's arguments on this first ground were very detailed. They set out sort of 6 steps. I'm not going to go through those in detail, but essentially the argument was that the judge had made factual findings about how Interdigital had given substantial discounts for past sales in its licensing practices. And it did that because of pressures it faced from holdout by potential licensees. And then So that they were relying on that fundamental sort of factual finding, but then saying that when the judge did the maths from the LG license, he just unpacked it without taking those non-Frand factors into account. And so he should have made some sort of adjustment to the 24 cents or done something to allow the past sales issue to be taken into account. Now, there are three slightly different judgments on these points from the Court of Appeal. So Lord Justice Arnold gave the main judgment, but then there's short supplemental judgments from Lord Justice Burse and Lord Justice Nugee. And actually, this really turned, I think, primarily on a debate about exactly what Mr. Justice Mellor had in fact found about the LG license and whether it was in fact affected by non-Frand factors. Everybody recognised that there was no finding in Mr. Justice Mellor that the LG license was not Frand. And in fact, when he considered permission to appeal in his form of order judgment, he essentially said that he thought that the LG license was Frand. But Lord Justice Arnold and Lord Justice Burse considered that this was inconsistent with the rest of Mr. Justice Mellor's judgment, where he did go into a lot of detail about how Interdigital had been, how they had effectively been required to adapt because of the practices by implementers, and a key way in which they'd had to adapt was by giving substantial discounts for past sales. And so that Lord Justice Arnold and Lord Justice Burse essentially found that Mr. Justice Mellor's decision was consistent with there being a non-Frand approach to past sales in these licenses, including the LG license. And so Lord Justice Arnold then found that there was fundamental inconsistency in Mr. Justice Mellor's analysis of the LG license, and that he should have done something to account for this non-Frand behaviour in relation to past sales. The question then, however, was what to do about it. And he says it does not begin to follow that Mr. Justice Mellor should have applied the future rate of 61 cents as claimed by Interdigital. And so the Court of Appeal said, well, we have to do what we can with the materials available. We're not going to remit this back to the Patents Court to look at again. And effectively, in a very brief part of the judgment, Lord Justice Arnold has a look at some of the other Lenovo 7 and the rates that came out of those, and then effectively says that the 24 cents is a bit too low, and that the Frand thing to do would be to increase it to 30 cents. And he says in terms, he doesn't pretend this to be a precise figure, it's not, it's just an estimate. So essentially, Interdigital succeeded in getting the rate increased slightly from the 24 cents to 30 cents, but they didn't get it up to the 61 cents that they were arguing for. On the next ground of appeal, again, Lord Justice Arnold dealt with this very briefly and said, well, the same issue arises on this adjustment factor of the 0.728, and this was a bit too low and it should be increased a bit, and he increased it to 0.75. And then on the third ground, on the rate point, on the cross-check, he noted that the judge had rejected the cross-check because it was inconsistent with the comparables analysis. And then he said that effectively the comparables was a much more reliable basis for estimating Frand than the top-down cross-check. And so he didn't look at it any further. In terms of Lord Justice Burse and Lord Justice Nugee, Lord Justice Burse agreed essentially with Lord Justice Arnold and agreed with the slight increases that he gave to these dollar rates and to the adjustment factor. Lord Justice Nugee has a section where he explains why he found this really very difficult to resolve. And I think he was much more concerned with exactly what Mr. Justice Mellor had in fact found, and whether he had found that there were non-Frand factors affecting the LG license. And he didn't seem particularly convinced by that. But then he said that he was going to follow Lord Justice Arnold and Lord Justice Burse, who had a lot more experience in this particular area, and he didn't want to give a dissenting judgment. So if you could just move on to the next slide, Roya. I've just tried to summarise this in terms of a bar chart to show the rates that were being considered. Sorry, Roy, could you just move on one slide?
Yes.
Brilliant, thank you very much. So this slide tries to put the change in royalties into perspective. So if we look at the middle two columns, so the third column in is the findings of Mr. Justice Mellor, which in total with interest came to about 185 million. The Court of Appeal, because of these increases in the dollar rates and the adjustment factor, increased the royalties to 178.3 million, and then told the parties to sort out what that meant in terms of interest. And according to some statements from Interdigital about the decision, apparently the total amount is around 240 million, so another about 55 million higher than the first instance decision. And then if we just look at the other points on this graph, so on the left-hand side, we have Lenovo's initial offer going into the first instance trial, so that was 80 million. They'd increased their offer slightly, or what they said the amount should be going into appeal, to about 108.9 million. And that took into account effectively the rate decided by Mr. Justice Mellor, but that was based on past sales not going all the way back to 2007 and on there being no interest. And then the other two columns show what Interdigital was seeking. So the fifth column is what they were seeking at first instance, which was the 337 million. But on appeal, they actually said, because they were saying that the rate should be higher and it should go all sales from 2007 and interest, they were seeking on appeal around 517 million. So we can see the amount that the Court of Appeal awarded was higher than Lenovo were suggesting it should be, but also was still substantially lower than the amount that Interdigital was seeking overall. And I think we've seen various comments from, well, certainly from Interdigital, and I've seen a few comments at least from Lenovo's lawyers, everybody sort of touting this as a success. I think when you look at the appeal decision in isolation, I would say it was a success for Interdigital in that they got the rate up and they maintained the findings on limitation periods and damages, but obviously it was nowhere near as high as they were actually asking for. And I wonder what they would have thought had they got this result from appeal at first instance. I suspect we would have still seen an appeal with them trying to get the rate up. Yeah, so that's the overall outcome on the rates. I'd say this doesn't really have such a point of principle as the points that Tess mentioned. It really is very much a detailed analysis of the findings by Mr. Justice Mellor. But I think it will lead to an increased focus on any non-Frand factors that go into an analysis. And I suspect in future judgments, we will see maybe a little more clarity from judges as to whether they're finding that a particular license that they rely on as a comparable is Frand or not. Okay, moving very briefly onto Interdigital's fourth grounds of appeal. Essentially, they were seeking a declaration that they were a willing licensor. This slide just shows the quotes from Mr. Justice Mellor's decision, where in effect he says that because all of Interdigital's offers, apart from one which had been characterised as a last resort and expressly disclaimed from being Frand, he said all of those offers were super Frand, and therefore he said that Interdigital were not a willing licensor. On appeal, if you move on to the next slide, Roya, the judge, Lord Justice Arnold, gave this very short shrift. You can see in bold, he says that since he's concluded that the Frand rate is higher than the judge's rate, that inevitably places a question mark over the judge's finding that Interdigital were not a willing licensor. But then he goes on to say that doesn't mean that they were. But most importantly, he says it's not necessary to actually conclude this because Interdigital hasn't identified any purpose that would be served by the court making a declaration to this effect. And this really comes down to the fact that in the English courts, if you want a declaration from the court, you need to show there's utility in it. And the judge Lord Justice Arnold basically said there's no utility in it. We don't really care about conduct anymore because we've come up with the rates. All right, moving on to the next slide. I think Tess was just going to pull a few conclusions and observations from this.
Yeah, so sorry, we're very running up against time, but as I think we've been through, basically, really the first instance judgment's largely upheld with the adjustment to rate. I think it's very clear that the English court is wedded currently to this willing licensor, willing licensee approach. What would those two parties agree? They're trying very hard, I think, to be balanced, to avoid the impact of hold up or hold out. So the willing licensee would pay royalties on all past sales and interest and royalties due, but that rate will be the Frand rate determined by the court. And, they think that will do justice between the parties, because you're never going to pay more than Frand, and the court will do what it can to make sure that all sales are accounted for and that nobody loses out because of any delay. They are, again, a little bit more guidance on methodology. I mean, this is interesting. So, the Court of Appeal sort of deprecates trying to be too precise about this, which is interesting. But another interesting thing is in their finding about how you've got to take the non-Frand factors into account. Mr. Justice Mellor, I think, tried to very firmly shut the door on the context in which licenses were agreed. He didn't really he just wanted to be able to read out the high level numbers, the sum paid over units sold, that's your rate. I'm not interested in evidence about how this license was agreed or what the parties were doing. But obviously, once you're delving, the Court of Appeal's kind of opened that door again a bit and said, well, you've got to think about whether there are non-Frand factors sort of infecting your comparables. And I think that probably does mean that evidence about how licenses were concluded might become more relevant than Mr. Justice Mellor had hoped. We remain very uninterested in conduct arguments. And in effect, absent absolutely extraordinary behaviour, I think basically the English court isn't going to be interested in who said what to whom when. They're just interested in setting the rate and then making sure that's accounted for fairly in terms of taking account of any delay. And I don't think it's the Court of Appeal decision, I don't think has shifted the pendulum really, because it's as you were. Our experience is that there's pro patentee points here in particular in terms of the limitation period, and obviously the willingness to set global Frand terms. And it's attractive to implementers. I think maybe not so much because the rates that are coming out are low, more because as Roy was talking about, you have the sort of scrutiny of the rates, the headline rates that perhaps you won't get in another jurisdiction. So again, I think what the English court is trying to do is to be fair between the parties, and that's what they'll continue to do.
Okay, thank you very much. We have a question from Ira Bloomberg. Ira, I can unmute you and you can just ask. You need to do #6 or something, or accept the unmuting, just ask a question.
Thank you. Can you hear me?
Yeah.
Yes, we can.
One of the last remaining questions is, what was the fee shifting conclusion in this case, if any?
So this judgment doesn't deal with costs of the appeal. The way the Court of Appeal deals with that usually is just on the papers, rather than having a hearing and a judgment on it. I think I saw a comment from Interdigital that they had been awarded the costs of the appeal. I haven't verified that, but it probably wouldn't surprise me given the way the particular point on the appeal came out. I don't know whether the parties will now try and argue that there should be a reassessment of the costs from the first instance. I suspect that might be a bit of a challenge for Interdigital, but I suspect it may also happen. There may be an argument about that.
And can you remind us what was the outcome of the costs on the first instance?
So I believe that the Lenovo were found to be the overall winner, because the offers were much closer to what they were asking for. You give me a moment, I'll just check the actual
No, I think that's right. I mean, it's interesting that if you know, as Pete's bar graph showed, actually, where the final payment that the Court of Appeal has come up with is actually quite a lot closer to Interdigital's, the position that Interdigital went into the first instance proceeding with, than the position that Lenovo went into the first instance hearing with. And if it were me and I were Interdigital's lawyers, if they hadn't maintained their sort of very ambitious case on appeal, I would now be saying, well, actually, in terms of the overall litigation, we've actually ended up much closer to what we were after than what you were after. So we should reopen that whole issue of cost for the first instance. But as I say, because Interdigital went into the appeal, you know, as Pete's graph showed, asking for, you know, even more. I'm not sure how that would work, but yeah, well, they did obviously win on the points of principle as well, and they did shift the dial up in terms of the rate. So yeah, the cost of the appeal is one thing, but I think the cost of the first instance might be a bit trickier.
Yeah, and those costs, they did largely go Lenovo's way. There were a couple of very isolated points on foreign law and a couple of other things that were dealt with slightly separately, but by and large, it was Lenovo recovered their costs.
Thank you.
Any further questions? No? Okay. No, thank you very much. I think it's a very important judgment. As I said in the beginning already, we are also seeing here a certain departure from the continent. I think this whole method that the question you about conduct, which we had our conference in Germany, in Munich, the 9th IP and Competition Forum, where it was with German judges, where they all discussed about what is a willing and unwilling licensee and licensor. And we're seeing in England and Wales, this is less the point. It's really about the economics. It's about the economics, stupid. And I think this is exciting and great times. And we were, for me, the punchline is that English courts offer balanced approaches where they think things through. We talked about it at the rehearsal where we said, well, is it expensive or is it not expensive? In Germany, you get a hearing which is quick and doesn't take 2 weeks and costs may be lower, but we thought, well, but what you get in England is a good, thoroughly reflected economic analysis and the valuation also, which perhaps may also now be starting to become more of interest in Germany. I very much hope that. And that compared to the rates and what you can get out of the courts, the costs are probably peanuts or not so important. And we also thought there's a lot of litigation funding available, there are different methods of getting a case funded. So we felt it's perhaps a bit more expensive, but you get what you pay for. But maybe Pete and Tess have their own punchline in terms of decision.
Well, certainly on costs, I think, yes, it's expensive to go through a Frand trial in the UK. I think the courts are trying to case manage these trials more carefully and trying to get the costs down. But, you know, for a license between a large SCPL holder and a large implementer, the costs are relatively small compared to the potential benefits that you can get in reducing the rates that are being sought by the patentee. So it's a cost benefit analysis. For very small players, it would be certainly a much more, relatively much more expensive process with far fewer upsides. So I doubt we're going to see many SMEs coming to the English court and asking them to do a Frand determination.
No, I agree. And obviously, in terms of looking forward, we're going to get relatively shortly the first sort of Frand decisions from the UPC, so that will, add a whole new ingredient into the strategy.
Thank you all very much for interrupting your summer holidays to discuss Frand decisions. I hope you enjoyed the webinar. Thank you for joining us today. We are back probably in September, unless there's another emergency, talk super urgently on a court decision or on a government's decision. big thanks to Pete Dumrell and Dr. Tess Waldron for the excellent presentation. And yeah, thanks for joining us all today. Have a lovely rest of the day. Bye.